is for entertainment purposes only, not to be taken as legal advice. Today marks yet another day on our new journey forward to our learning. Over the course of the last 4 months, we covered thoroughly the final process of Patrick Devine. Now that we have established our standing as individual bankers, we now move into processes. Today's discussion is the final day of our series about administrative process. So I'm going to cover the administrative step-by-step procedure with also examples. It is important to note that while I'm your guide in this course, I am not the originator of this information. The insights we will explore have been brought to light by many great gurus, including Patrick Devine. His tireless research and dedication led him to uncover a remedy for freeing oneself from the monetary system. After 9 years and over 5,560 documents, essays, and submissions to various governmental entities, Patrick Devine discovered the key to liberation in 2016. Then he disappeared and said, "Now it's up to you to set yourselves free." This live course with 100 students will cover the final process of Patrick Devine's great works, as well as information from others who helped him along the way. Let's begin. I want to start off by saying, it's been a fantastic week to be able to teach on this subject about administrative processes and everything. And I am super excited also with the amount of response that we've gotten to our plan of action as it relates to people getting their remedy in just preparing, planning, and executing a step-by-step process. I like to call it the big three. The big three kind of looks like this, and I cover this a lot in some of my consultations privately, is, we have 3 aspects by which that we try to get remedy in this truth movement, okay? Step number 1, I covered very thoroughly the last 4 months in the Patrick Devine's final process of establishing a UCC contract trust, which is for you to become the secured party over your debtor. This is important for your status correction because you be able to utilize what? Negotiable instruments. That's really the whole name of the game. I want to be able to spend monetary funds through contracts. That's an advantage. And it's a huge advantage because now it's no longer utilizing Federal Reserve notes in order to try to pay off bills and balances. Now it's using bonds and security interests in order to offset debt charges. The second aspect of your step-by-step process is going to be to separate assets. Patrick Devine always separated his assets into different entities, whether it was his vehicle, his house, or anything such of the like. And this is why here at Creditor Academy, we discuss business trusts so thoroughly. Business trusts give you such a huge advantage as it relates to privacy, limited liability, advantages through probate, tax avoidance, and so on. And not only that, but it really allows you to live up to what the Rockefellers' famous quote is, which is to own nothing, control everything. So you're separating your assets into different trusts. I personally have about 16, 17 different trusts with different assets held inside of it. I have business credit cards and different business trusts that I own, and I don't take anything personal anymore. So that's one of the big advantages of how you are moving along in these private processes, is to make sure that you're operating in the private in the first place. And you haven't truly operated or started operating in the private until you started separating all your assets from the personal liability of you holding it. The third step in this truth movement that we are covering is the actual processes themselves. The processes, like we're going through in my remedy series, has a couple components to it, but high level, this is what it entails. it entails an administrative process with a negotiable instrument. And in your administrative process, you're referencing what? Your status. Hey, I'm a secured party. The next thing in your administrative process is you're relating the national republic laws of the nation. Like, remember when Patrick Devine said, I'm an Article 4 individual banker. You know, I follow the 8th, 11th, and 14th Amendments. You know, I'm a bounty hunter. I invoke my rights under Section 1 and 2 of Article 4, and so on. So those are the national laws that are applied to your administrative process that give it its bite, you know, and then the second part is the republic laws of your state, because every state has different republic laws. So now you have status, national laws, state laws. So now you just have the contracts that you signed with the bank, the credit card company, the loan that you got for your vehicle, whatever it is that you're trying to remedy, and you're adding these 4 elements together in a description of what you're trying to accomplish in your administrative process to do your discharging. So that's a lot of information. That's a lot. It's a lot to take in. And this is why it takes some time for people to get their remedy. It's oftentimes that their process isn't right. Administratively, they might be doing it correctly. However, if you don't have these nuances of referencing your status and what republic laws you're operating under and relating it to the original contract that you signed, that's how you get pushback, right? And this is why the attorneys are so proficient at contract law and why I personally bring them in. So those are the high-level key 3 components to this whole truth movement. Try to keep it as simple as possible. Since I started this YouTube journey, I've wanted to go ahead and bring people along with my vision of this type of organization, and to have staff like Patrick Devine exclaimed that he had staff for his private bank. He had his banking examiner, his private attorney general, his individual banker, his bounty hunter, and his clerks and his trustees and so on. And so the same way he has staff for his private bank is the same thing that I am doing with Creditor Academy and my private bank, is to make sure that I have adequate staff as well. Okay, so the other thing is that I have come into this kind of channel to go ahead and encourage you and to help do my best to give you high-level descriptives of how to go through these processes, as well as how to think about how to go around corners when you're trying to apply these remedies. But I am just a guide. At the end of the day, this is your journey. I'm not here to be your forever teacher, not here to be your guru. This is a journey that you have to go on. And only you, by going through the gate, are going to be able to get your remedy. Not any single person can do it for you. Is I learned kind of being in this movement, an advantage is connecting with others. And very gratefully, so many of you have connected with others in this like-minded space and have now working together. You have board of directors. A lot of you have business trusts together. I'm doing business with you. And a lot of you are coming to us with your attorneys. And now we get to go ahead and do private processes on a shared vision. And all of that is super exciting. And I'm super pumped for what the future brings for all of us. Okay, any other updates? Nope, that's pretty much it. Let's get in today's discussion, which is kind of an overview of the step-by-step process that we have been covering the last couple of days of the administrative process. So let me open up my document. Okay, so I created this document earlier today so I can kind of cover what we've been talking about the last couple days, and then we'll go over examples. Okay, zoom in enough on that. All right, so this is the private administrative process step by step by Creditor Academy. An introduction is to understand the context. The current commercial process operates in the realm of fiction, involving legal fictions like countries, corporations, and individuals. Real beings or living people cannot operate in this realm directly. They require a commercial vessel, a straw man, to interact with the legal system. Private administrative process. This process is essential to resolve claims before entering the public sector. Courts today are admiralty equity tribunals, meaning equity principles, meaning fairness and just dealings, must be observed. We want to review what are the key principles of these equity. What are the key equity principles to remember when doing our administrative process? Number one is come with clean hands. Number two, no equity for those who commit iniquity. Number three is fairness and right dealing regulate interactions. Number four, every right must have a remedy. Very important. Every right must have a remedy. Equality is equity. And equity follows the law. Seek equity by doing equity. No profiting by wrongdoing. To receive equity, give equity. So those are the 9 maximums or principles of equity. Number three, it's the importance of clean hands and equity. And this really covers the dishonor, which is the huge part of how we get our summary judgments. But dishonor is failing to honor equity leads to losing any case, as the judge will always favor public policy and uphold revenue collection. The solution is always act with clean hands and exhaust the private administrative process before bringing a claim to the court. This ensures you have perfected claim and clean hands, giving you an advantage in any judicial proceedings. Number four, the administrative process steps. So this is high level what we've been covering the last couple days, last couple classes. Step one is use affidavits. Conduct all communications through notarized affidavits or asservations. Step two is engage a notary. Always send and receive documents through a knowledgeable notary. The notary acts as a disinterested third-party witness. Step three, send notices. Have your notary send notices to all involved parties, respondents in their private capacities. Step four, avoid dishonor or traverse. Do not comment on or deny the content of the respondent's communication. Instead, send a conditional acceptances and negative avertments, requiring the respondent to prove their claim. So it's almost like, you know, hey, did you go late last night at midnight inside of the cookie jar and eat the last cookie? You don't respond by saying, no, I didn't do that. That wasn't me. You will go back and have a conditional acceptance or a negative avertment saying, prove to me that I was in the cookie jar. Step five, the burden of proof. Remember, the burden of proof lies with the party making the claim, not you. Number six, invoke acquiescence by silence. Set a time frame for the respondent to prove their claims. Their failure to respond constitutes their agreement that your position is correct. Number seven, finalize the process. After completing the private administration process, proceed to the public side. Engage the notary for a notarial protest process, establishing the following. One, that it's a private and public exhaustion of administrative remedies, a complete set of stipulations supporting your position, and a summary judgment and judgment in estoppel in your favor. This is the end game here, to get that summary judgment. Part number 5, establishing stipulations, the result of process. Through this process, the respondents admit and confess the following. You are the creditor. They have no evidence of being a creditor. They owe you the specific sum. They have failed to state a valid claim. Number 5, any future proceedings against you would constitute a libel on the public record. Step 6, the final steps. File an administrative judgment. Record your administrative judgment with the appropriate recorder. Then a public record. The notary's involvement brings your private information into the public record, protecting you from further court actions against your straw man. Remedies available. Once the private affidavit administration process is complete, additional remedies become available, such as a habeas corpus, a criminal affidavits, and maritime liens. You know, this is where you could do a commercial affidavit process like Patrick Devine did. And with his cap, he was able to do what? A banker's lien. Okay. And that about simplifies the complex concepts and processes, making it easier to follow and implement the private administrative process. So there's the high level of what we're covering. So now let's go into something more practical, which is examples of the documentation that is utilized in an administrative process for a remedy. Allow me to open up the right folder. Where is it? Okay. All right. So I'm going to share this. All right. I have a little example that I like to use. Like I said, everything starts with an affidavit. This particular example I like, and I'm going to show you all the documents involved here. But basically, this is John Paul Smith. He sent a notice to the International Revenue Service to set off his bank account. He enclosed documents showing his bank account balance had been adjusted to $0, including a statement of account and IRS Form 1040-ES endorsed to show the account was paid in full. As the IRS did not respond, Smith is now requesting that his bank, which is OZ Financial, also adjust the balance of his account to $0 to reflect the set-off. So he provides an affidavit of specific negative avertment stating that he has seen no evidence the set-off documents were defective or that the obligations were not satisfied. So Smith requests OZ Financial approve or correct a statement of account showing a $0 balance within 14 days. So that is the situation, and we are going to go over each one of these documents that covers that issue. So like I said, we want to do step 1, which is the use of affidavits. And the First one is conduct all communications through notarized affidavits or avertments. So what is this affidavit of specific negative avertment say? The undersigned affiant, John Paul Smith, hereinafter affiant, does solemnly swear, declare, and state as follows. 1, that the affiant is competent to state the matters set forth herein. Number 2, that the affiant has knowledge of the facts stated herein. And number 3, all the facts herein are true, correct, and complete, admissible as evidence, and if called upon as a witness, affiant will testify to their veracity. Okay? The plain statements of facts. Affiant has seen no verifiable evidence of a defect in the offer tendered for settlement attached in Exhibit A hereinafter, known as tender for OZ Financial. You can replace this with Wells Fargo, Bank of America, whatever it might be, and the account number to that bank. Hereinafter is called the account. On or about the date to the Internal Revenue Service Criminal Investigation Division in Ogden, Utah, hereinafter is known as the recipient, and the affiant believes that no such evidence exists. Affiant has seen no verifiable evidence that the tender does not satisfy the obligations associated with the account, and affiant believes that no such evidence exists. So what are we saying here? So we're saying that that there's no evidence of tender that is outstanding on the account. And like I said, this is an example where he's trying to say that there is a zero balance of dollars on that account and that he doesn't own anything else. So he's trying to communicate is hey, the Treasury Department takes care of the offset discharge, and so they'll zero out the account on behalf of what's left in the bank account where he owes the tender. So he's doing an offset of that. Affiant has seen no verifiable evidence that the recipient's failure to respond to tender does not compromise the recipient's acceptance of tender and agreement with the terms set forth therein, and affiant believes that no such evidence exists. Affiant has seen no verifiable evidence that recipient's acceptance of tender does not obligate the financial institution to issue a statement of account showing a $0 balance for account, and affiant believes that no such evidence exists. You have 14 days from the receipt of this letter in which you can respond to or rebut this affidavit of specific negative avertment. Unless you request in writing an extension of time, failure to respond or rebut shall convey your assent to an agreement with all the facts herein, in witness whereof I hereunto set my hand and seal on John Paul Smith, State of New York, and the county, and then he got a notary public. So let's go back to some of the documents we talked in the previous class, which was, where was that fun folder I had? Oh, where's my fun folder? Oh, no. Ah, where did I put it? The certificate of okay, give me 1 second. I might already have an example in here. Oh, and let's go over, while I'm looking up that other thing, let's go over all of the exhibits that are inside of this document. He has a certified mail form. And this is what I'm looking for right now, a notary certificate of service, okay? So he is utilizing a notary, and a notary certificate of service is the document we reviewed last time that kind of described what's inside of the certified mail form. It's that and the notary certificate of service, she verifies by the title of the document, the number of copies of pages, and what the title of the document is. In addition, in his document, he has a notice to set off accounts that he's referencing that we'll go over. He has a private registered set off bond. He has a UCC financing statement. He has UCC assignments. He has a statement of account noted as accepted for value. He has an internal revenue service form. And he has a certificate of non-response, okay? So some of the documents we went over in the last couple days, and these are everything that you need for your administrative process. And the reason why is because your private registered set-off bond is what you're utilizing to set off the account. This 1040 ES form is to show for the taxes of the set off, okay? And then here's the statement of the account you accept for value. Accepted for value is meaning that you accept the responsibility of the contract, right? And then your UCC financing statement is showing who the secured party is over that account as well. So let's go to, oh my gosh, here it is. Okay, I just had to scroll down a little further. So here's a notary certificate of service. It is hereby certified that on the date below, noted below, the undersigned notary public mailed to, and he went to that, the chief financial officer, the CFO. And remember when Patrick Devine sent to the CFO the GSA letters? It's kind of the same level of communications that we did with the GSA as we're doing with this administrative process, okay? And the notary is certifying what is being sent. What are they certifying? They're certifying that the notice of tender for set-off is in there, that the affidavit of negative avertment, the request regarding the statement of account, everything in Exhibit A, and also the notary certificate of service that's signed. Now the notary public signs and seals it from there. And remember, the whole point of this is to get to the next section, which is if in that 14 days, they don't respond to your negative avertment of your affidavit, what happens? We then send a certificate of non-response, okay? To, again, the state of New York, a Suffolk, and that specific bank. And we say what is said by John Paul Smith is requesting a rebuttal or an acceptance of notice of tender for set-off and affidavit of specific negative avertment and request regarding statement of account. The time limit having elapsed for rebuttal by non-response. The non-response whereupon the notary public signing below does publicly and solemnly certify the what? The dishonor as against all parties by reason of non-response. This is my biggest way I get my summary judgment, is by showing the certificate of non-response here. That's very powerful. And then I have a testimony. In the testimony above, I have signed my name and attached my official seal, which is the notary public seal. They got to do that. And then you got to send them a notice. Okay, so now you just got them into what? A certificate of non-response. Now we go into a notice of fault in dishonor and opportunity to cure. You want to give them an opportunity to cure. I mean, like, you know, this falls into the realm of mistakes. Maybe you got sent to the wrong place. Maybe someone didn't respond in time. Maybe, you know, somebody, whatever the case may be, you give them another opportunity to cure after you give them their notice of non-response. And it says, undersigned John Paul Smith, who in the care of the notary, in the matter of, and the account number, which is the bank account number of the OZ Financial. And then Almer Gulch, who's the CFO of the bank. This instrument is a notice of fault in dishonor upon the instruments presented under notary seal by the undersigned on or about February 2011 with a certified mail number. Remember, all of these are certified mail numbers. Presentment on and notary name. Notary, at the request of the undersigned, presented the following instruments for acceptance: notice of tender for set-off, the affidavit, and the request regarding statement of account. And then here's the dishonor part. By the terms and conditions of the agreement resulting by the offer and acceptance of the presentment, the respondents are under the duty and obligation to timely and in good faith respond to the notice of tender for set-off, an affidavit of specific negative avertment, and request regarding statement of account within 14 days by executing a verified response point by point with evidence that is certified to be true, correct, and complete, to be received by, not you personally, but the notary. They allowed, we always say, hey, we allowed the 14 days. It now deems the instrument to have been dishonored. Fault. For failure of the honoring of the offer is placing the respondent at fault. This presentment is the good faith offer by undersigned for an extension of the time to respondents for making the required presentment by an additional 10 days from this postmark of this presentment. Responding has 10 days from this postmark of this presentment for making presentment at the notary to address given above. For the respondent's failure, refusal, or neglect in the presentment of verified response, as a sufficient verified response is defined below, to this notice of default in dishonor and opportunity to cure, is consenting with the undersigned entry of a notice of default in dishonor upon the respondents and issuance of a certificate verifying the respondent's non-response, and the respondent's acquiescence and tactic agreement with all terms, conditions, and stipulations. But my God, doesn't that sound like an attorney wrote that? That's so wordy. But it's very thorough. Then it goes into further responses, further description of the default, and it goes into each one of these point by points. Default is with the respondent's confession of judgment to the following. So they're confessing to the following: that one, the above referenced instruments is sufficient for discharge. The balance due on the alleged loan is now 0. The respondent's irrevocable conveyance of any and all rights, titles, and interests in and on any and all collateral in the association with the security for the alleged loan to be undersigned. And it goes on and on and on. It really just hits it home, basically, that if by not responding, they waive all their rights and immunities and defenses. So that is also sent by a notary public. You can see how important it is to have a notary public for these processes, to know someone personally or to have a business relationship with an individual so you can execute these on your behalf, because it's a little bit of a process. Now we get into the fee schedule. Okay, so now a lot of you have maybe seen the fee schedule before. The fee schedule is basically to say, hey, I'm giving you a notice that if because of your upon default in dishonor, these are my rates if we do any arbitration hearings, if we do any mediations, if we do any formal or informal meetings, if we do written communications, telephone, electronic communications, or time extended. This is the fee schedule to say, hey, now that you're in dishonor, I'm now charging you for my time. And this is why you can get an even faster summary judgment, because now they know that they can be charged for each one of these services that you provide. So they just don't even want to bother, because now you can go ahead and try to collect on these charges and fees. We're going back to Exhibit A once again to kind of recap. Again, it's the certified mail form, the notary certificate of service, the set-off account, the private registered set-off bond, the UCC financing statement, the assignments, the statement of account for acceptance for value, and the Internal Revenue Service Form 1040 ES, and now a certificate of non-response. And then there's the dates by which they were all sent for non-performance, non-response, certificate of non-performance, notice of default. It's basically just going over all the dates and times that you sent everything. Again, imagine you go into a judge and how thorough this is for how you're exclaiming everything. Okay. And then the notary does what again? Does a certificate of service all over again, right? Because what did you just do? You just added new forms. So now we have to do another notary certificate of service. And what they're doing now is just verifying the same thing. Hey, inside of this package, we sent a fee schedule, a notice of default and dishonor, an affidavit of specific negative averment, a notice of tender to set off, a request regarding statement of account, and the copy of an Exhibit A, and again, another notary public. Then after that's set, guess what? We're all the way back here, the certificate of non-response and non-performance. This is getting closer to the nail in the coffin now. The non-response whereupon the notary public signing below does publicly and solemnly certify the dishonor against all parties by reason of non-response. Okay. That's high level. Now let me scroll up a little bit. So when we were going through that, I mean, I started with the affidavit first. I always like starting the affidavit because you start an administrative process with an affidavit. But as you saw in the list of documents that were submitted, there was the notice to set off accounts, okay? And the notice was sent to no other than the Internal Revenue Service, Criminal Investigative Division in Ogden, Utah. And then the service was for this register mail number of these documents that were enclosed for the set-off. The documents that were enclosed were the statement of the account, the accepted for a value, exempt from levy, discharge all presentments and related fees, adjust the balance to zero, a private prepaid treasury exemption form, and a charge to save the same. And that's the all caps exemption number, which is the Social Security number. And this is the Social Security number without dashes. These are processes that can be interchanged. I want to give you an example. So this person did an accepted from value, exempt from levy common stock, and then he used a bond to offset the charges. That's one way of doing your administrative process. And this, for this person, all they chose. Now I want you to imagine that you did this with, instead of, you did it with, yes, continue editing. Now imagine you did it with GSA forms, SF30, 14, 14, 14, 16, 14, 18. And I want you to imagine you did a promissory note. I want you to imagine that you did a, what's another one? We already did conditional acceptance. Oh, or actually, I don't think this person did a conditional acceptance. Did we go over that? Acceptance. I don't think I said it. No, I think it maybe was. A conditional acceptance. We'll go over a conditional acceptance here in a minute. I have a document for that. Or maybe you did another process and you did 1099A, C, OID. Maybe you did somebody name another process. What's another popular process that you guys have?
And you use the bill of exchange, Paul?
There we go.
The
bill of exchange, BOE. Someone name another process.
Promissory note.
Already got that. Name another process.
1099.
I already wrote that. Name another
You already
process.
got it up there.
What else?
Coupon remittance.
A remittance. Yep. What else? Name another process.
Request for dispute resolution.
Sure. Name another process.
Land patent.
Land patent. There we go. Okay, someone name another process.
Did they say negotiable instruments?
Yeah, I'll write that. Negotiable instruments. NI.
Mortgage reconveyance.
Reconveyance. Okay, name another process.
Arbitration.
Well, yes, if they pay your fees, right? Arbitration. You could go into arbitration. Absolutely. How about a silver surety bond? Okay. Name another process.
Oh, yeah, you're right. The silver surety bond. You're right, Paul.
Absolutely.
Would an indemnity bond be part of that?
Indemnity bond. Okay. Great. Utilizing that. Let's say, oh, hey, I'm doing an SF 1047 for reimbursement. Okay.
Oh, yeah, that's right. Yep, I forgot about that one. Yeah.
Hey, how about this that I hear 1,000 times? Borrow from yourself.
Yeah, yeah.
I know it. Okay. See, there's endless processes to add to an administrative process, and you're just listing out what that negotiation is, and it doesn't have to be no OZ Financial, Wells Fargo. Imagine this was the title to the vehicle or something like that. But, you are communicating between your status with the Treasury Department and whatever third party for the statement of your account. So that's why administrative process, I add so much to it. Now, the next document that he had in there was the notice of tender for set-off. This is a private communication between the parties. Notice to agent is notice to principal. Notice to principal is notice to agent. There's the notary, the person's name, and the care of the notary's name. And here's the respondent, the CFO of the bank. The instruments of tender for set-off in after is tender for set-off of the account number, the Internal Revenue Service Criminal Investigation of Ogden, Utah. The tender is deemed accepted for set-off of the account. The undersigned requests that the balance of the account be adjusted to 0. Enclosed here within is the request regarding the statement of account. So again, he's now giving the days to do that. And that's why after that, he's going to have his affidavit. Okay. Then he has a request regarding a statement of his account. And let's read into this. This one's a very interesting one. This is a record authenticated by the debtor requesting that the recipient approve or correct a statement indicating what the debtor believes to be an aggregate amount of unpaid obligations secured by collateral as of a specified date and reasonably identified the transaction or relationship that is subject of the request. The recipient has 14 days to comply with this request and provide an authenticated record. If a response is not received within the time provided, your non-response will be construed as your tacit acquiescence and your acceptance and honoring of this instrument as a true statement of an account. And the statement account is, hey, here's the date, here's the creditor, here's the debtor, here's the account number, and here's the balance that's due. I declare under penalty or perjury, then it's your name as the secured party. Then it gets back out down to this, and now we have all the Exhibit A's that are a part of this and attached. Now, one other element to this is the conditional acceptance for value, okay? And a conditional acceptance for value is for proof of claim upon the corporation's contract for the determination of meeting of the minds, fraud on the contract, and the unconscionable contract or agreement for commercial discharge. Dear Ms. Smith, CFO, again, sending to the CFO of the bank, I am in receipt of the conditionally accepted for value, which means honor, your statement for the month date, a copy of your letter document is enclosed. Now, this is very important because the acceptance for value is now going to start naming out the proof of claim. And the statement is, as I want to resolve this matter as soon as possible, I am initiating this private administrative remedy to determine such matters. And I agree to continue making payments predicted upon your proof of claim. The necessary proofs of claim are set out below. Number one, you need to respond that something that gave full disclosure, okay? When dealing with said contract as the U.S. bankruptcy form of payment, what was loaned, etc. Next, a proof of claim that the agent in the sending the undersigned demand for payment of debt letter via U.S. mail does not constitute mailing of a fraudulent claim or committing mail fraud, okay? Proof of claim that respondent as an artificial entity creature, like Patrick Devine said, those for-profit corporations such as the banks, the State Department, etc., created under the laws of the state of state and doing business in the state of state by and through its officers, board of directors, employees, and agents are not bound to support Article 1 and the U.S. Constitution that a state-created entity reads, no state shall make anything but what? Gold and silver coin as legal tender in payment of debts. So, as it's stating here, it's a demand for payment of debt, right? So you're arguing that gold and silver is the only legal tender in the payment of debts, and that any such thing as gold and silver coins exists as legal tender in payments of debt. So now we get into the next part, the proof of claim that the value or substance demanded is demand for payment of debt is in the nature of valuable consideration called money. That's the Federal Reserve notes from the for-profit corporation. It is not gold or silver or legal tender, and is in compliance with Title 31 of the United States Code 371 and the United States Code 152. Proof of claim that respondent inquired or knew that the undersigned had or has access to lawful money of account to pay the contract debts at law without becoming a tortfeasor. The proof of claim that the undersigned has had access to money that constitutes lawful sufficient consideration. This person submitted a bond, so that's what they're going to use as their sufficient lawful consideration. The use of the Federal Reserve note or instrument certifying conveyance of Federal Reserve notes is not only a promise to pay. The legal tender and notes or instruments certifying conveyance are good and lawful money of the United States. And it goes on and on and on and on. All the way to 23 different points. What happens after the 23 different points? Well, we get into the general statement. General acquiescence or non-response by respondent of all 23 points that were just made to provide the above proofs of claim will constitute the agreement and formal acceptance. Respondent will have, by your non-response to the state of claim upon which relief can be granted, Otherwise, it shall operate as a general acquiescence relative to this presentment. Response will have admitted there is no valid claim of action arising via contract or compelling the undersigned into an unconscionable contract, and that there was no meeting of the minds in respect to the alleged contract. You will have formally accepted each and every fact herein as they operate in favor of the who? The undersigned. Who's the undersigned? That's you. So due to your silence, and estoppel is in effect. Remember Patrick Devine, when he did his administrative process, he had what? An estoppel by deed or estoppel by banker's lien. But yeah, he had estoppel by deed. I think I remember his thing. You admit to your non-response to bring forth proof of claim in support of clean hands. Remember in my in the step-by-step, okay? What is this all about? This is all about you coming with clean hands, okay? And no equity for those who commit inequity, fairness and right dealing under a regulatory interaction. But you need clean hands. So clean hands, full disclosure, good faith dealing pursuant to the Fair Debt Collections Practice Act, as it may apply to your presentment in regards to this alleged transaction contract as referenced above. Or in previous he has a bill of exchange was tendered and not accepted. So he sent a bill of exchange. You agree that the matter account debt is discharged as an operation of law and tender of payment in bankruptcy. Due to the time-sensitive nature of this private matter, under a necessity, you are to respond with proof of claim. That means answer all 23 of those things point by point within 10 days, plus 3 days grace granted by return service of certified priority mail return. Should you fail or refuse by non-response, so it's either fail or non-response. So they can respond, but if they fail or refuse to respond to all 23 points of your proof of claim within that time frame specified in this private matter, the general acquiescence and acceptance will be taken on your part as formally exercised, which is performed pursuant by your silence. This agreement shall have the effect of an instrument under seal, sincerely, without prejudice, we went over that last class, and signed by the attorney in fact. This is why you are badged, because you're a private attorney general and an attorney in fact. You just named the facts. And then you have a notarial seal at the very bottom acknowledging this assent. Now, where does this document have to go? Who can tell me where this document needs to be listed? Anybody?
Where it need to be listed?
Yeah.
CFP.
Legal department.
What do you mean?
The indentured,
no. Where does this need to be listed in reference to a notary? Where does this document need to be listed?
CFO.
In reference to a notary, what does a notary have to do with this document besides notary?
Put it in their book. Put it in their notary book as documentation, witness. Yes.
Kind of.
Certificate of service?
You got it. It's the certificate of service. They have to list it as their certificate of service. Good job, Elle. Absolutely. So you kind of see kind of the flow of this. We have affidavits, we have negotiable instruments, we have certified mail, we have notice of non-response, we have notice of default, we have notice of default to cure, we have a fee schedule, we have, what else we have? What else am I missing? We have a UCC financing statement, we have a statements of the account itself, we have and we have our notary certificate of service in there. We have a notice to set off the accounts. There's quite a list as it pertains to this administrative process, but it's so important to have these aspects. The reason why is because this is all to organize you enough for a summary judgment. Because once you got that summary judgment, guess what you're going to do? Who can tell me if soon as the judge signs off on it, what do you do with that summary judgment that has its unique number?
Issue it to your adversary.
No. Next. Who can tell me? Who can tell me?
I didn't hear the question. Say it again.
When you get, when you get a summary judgment from a judge on your case because you presented the facts, what then do you do with that summary judgment case number?
Secretary of State.
Nope.
Can you put it on a UCC and a lien?
Treasury.
So close. Oh, I love how you
Dash it in at the clerk of court.
Amazing. A lot of good responses. The first thing that you want to do is okay.
Non-UCC.
Gotcha. So the first thing you want to do is now show, because you are the secured party over that account. So now you got to put the summary judgment court case number in your UCC3. Because now you as the secured party own that judgment. And now that you have a lien over it, now it becomes your property. Now that it's your property, what happens if someone comes after your property? Now you have a right to defend your property. And you can go ahead and do a cap process on them. You can hit them with your fee schedule. But you have a complete ownership now over that case. And now you brought it to the private side. So that is the step-by-step high level of how to execute, by example, an administrative process. There's a lot of nuances to administrative process, and there's a lot of different ways to write it. But once you have the foundational documents and you start choosing processes that you want to apply for whatever situation you're trying to remedy inside of your administrative process, the execution by which, if it's done correctly and you stay in honor, you're able to get that summary judgment. And that summary judgment is the gavel to say that, hey, I not only won my case, but this is, I'm fully discharged. And you're going to do an administrative process, not 5 times, not 10 times, not 100 times. You'll do it 1,000 times. Everything you do is by administrative process. This was the foundation by which I've done my processes for my private stuff. It's where I started. And because it really focuses on what? It focuses on clean hands It focuses on no equity for those who commit inequity. It focuses on every right must have. Decline. Focuses on equality as equity. Equity follows the law. It seeks equity by doing equity. No profiting by wrongdoing. And to receive equity, it gives equity. So it's following those maxims very closely. So that's why we really want to stay in honor and you'll be able to do it. Now, as you can imagine, high level, I know as I was going through all of those documents, there's a lot of nuances to that. And I want you to just have that all go through one ear and out the other, right? On every little bit of the legal jargon. And all I want you to do is know the high level of how an administrative process is applied and see why the importance of having a legal team execute these administrative processes is extremely beneficial. My attorneys do it for me. They know how to do my administrative process. They know what my status is. So they reference my status like we did inside of here. The person, what did they do? They wrote their name as the secured party, and then they put their exemption number. That's a reference of their status. All those laws, rules, regulations, and codes inside of there, they reference Article 1 and Article 4 and the others. Those are the national laws. Then he did the state republic laws of his state and even did some case law. And then he did what? He took the actual contract of his account and applied it to his administrative process as well. He put the account number. He took probably whatever presentment they sent to him that he owed on the account, and he went ahead and rebutted that. So all of the elements that I was describing earlier are all involved in this. And everybody's situation is different. It's so different. And you can see why, even though there's some spaces where you can write your name and do all that, like it does take some finesse to add to things that are specifically relating to your situation. For example, those bullet points, the proof of claim bullet points, all 23 of them, I've done a proof of claim bullet points where I went up to like 50 or 60 points because I had so much I could have covered. I was just being super thorough. And I've had other proof of claim administrative processes where I only have like 5. But that's because I was like, you're not gonna even get these 5. So everything's adjustable. So I don't want you to look at these examples. What I'm going to do is what I presented in class, I'm going to put inside a file folder that's going to be accessible if you email creditoracademy@gmail.com. So then you can get access to the administrative process documents that I just presented in class. You can kind of read and digest it. You can look at my high-level step-by-step on how to do it. But start to think to yourself, how do you keep yourself organized while you're doing these administrative? Like I said, when I started the administrative process remedy last week, we started with what? We started with, hey, get some folders. Hey, get your little red thumbprint. Hey, get a filing cabinet. Get a printer. I even gave you some other documents to keep you organized as well. And yeah, I've done a lot. Okay, so let's now go.
How do we get
the questions in order, Al? Brian McGowan, let's go with you for your first question.
Yes, I just had a question regarding the meeting tomorrow. There'll be a link sent?
Yes.
Okay.
Yes. Right.
I wasn't sure. I figured you'd send something probably sometime in the morning.
Absolutely.
Okay. Yeah. All right. That's all I have right now.
Problem.
Okay. Thanks.
Crown in the right Commonwealth. Let's go to you.
Greetings, everyone. I hope you can hear me.
Yeah.
Audio drivers are not the best. I've got a question in the chat relating to the possession of the birth certificate, if we are in possession of that birth certificate unendorsed, are we technically not with clean hands? Are we still deemed to be the debtor?
No, because you're referencing your status correction as the secured party, and that's why you put your exemption number that goes along with it, or the account number. The account number is that certified mail return receipt green card number after the Treasury Department accepts all of your registered securities and bonds, which you're then going to use for the set off of your as a negotiable instrument to your contractors.
Would that strictly be a bond with the Treasury, or let's say, for example, you can bond another Crown agency, for example, that's able to offset, for example, I guess the traffic authority, for example, and if you had some tickets that you can offset,
Right.
would that performance bond or indemnity bond still be deemed with clean hands if you still retain possession of the birth certificate? Because there's a little bit of confusion as to who the secured party is, and do you always want to be the secured party in the framework of, let's say, a mortgage that hasn't been discharged or is in question?
Mm-hmm. Well, you want to be the secured party over all of your contracts. It just means that you hold the superior position over all other creditors. And when you have the superior possession, then you have the right in order to utilize negotiable instruments for set off, but it also means that you get paid first, right? The other creditors are all second.
Even if, let's say, a mortgage has taken place, or an agreement has taken place, say 20 years ago, and we then go and correct our status, do we then assume that superior position?
Yeah, there's no statute of limitation on claiming your property or assets. You can go as far back as that you want to go and to claim it back. Yeah.
Thank you very much.
No worries. Happy to help. Tanisha Wilson, let's go to you.
I'm sorry. I forgot what I was going to ask you. It'll come back to me. Sorry.
No worries. Amy Faye, let's go with you.
Hey, Paul Michael. When our attorneys are preparing these processes for us, I believe you said it's best to really hit them with a shotgun, hit them with a number of processes at the same time. Am I correct that I remember that correctly?
How I organize, each person's different, but how I organize is I get my attorneys to do the foundation. The foundation is I like, hey, you need to be in consistent communication with one of my 5 notaries, okay? That I can reach out to at any time. And my attorney communicates with my notary. The notary, then he organizes all the documents and puts in the language. He knows these documents that I've presented to you today, and he makes the necessary edits in order to apply it to whatever situation I'm trying to remedy. And then my attorney automates it by first doing the administrative process, usually with set-off bonds. I mean, that's like 90% of what I do, is I just do a bond and I reference the bond, because you can draw from the bond. And when I'm drawing from the bond, all I got to do is just make sure that my accounting is in order. So if it's like $1 million bond and I use it for 200,000, well, there's only 800,000 left, right? But then I do another administrative process, take from that same bond, then do the accounting from there and do the accounting from there. But it's all revolved around administrative process. I only really bring in other processes if I think it's necessary, or if I just try to do the simplest thing possible. And the simplest thing for me is utilizing bonds.
Okay.
Yeah.
And The notaries that you're using are using the online ones that you know will provide the services you need, or locals that you have to hustle your butt down there?
I have, so what I do is for my attorneys is I do this. I'll show you. So oh, there it was. It literally popped up. Okay. So here's what I have my attorneys do. They go to notarize.com. I have an account, and on that account, all of my personal notaries that I know, we operate on this account. This is, if you're a notary, you can create an account from here and service any client independently. And then you can charge whatever rate that you like. So all of my notaries have a Notarize account. It's a popular website. And then I go on there, and my agreement is they know how to do notary protests. Normal notary, I mean, it's hard to get a notary to do a notary protest because a lot of them just don't want to be involved with it. So then we do the notary on there. Then my notaries go to here. There we go. Then my notaries go here to iPostal 1, where we have like a virtual, I have a virtual mailing office. Now I have access to the virtual mailing office, and I actually can add people to the account that can also see what's being returned, but also the notaries have their own iPostal account as well. So when we do the online notarization, then they take that and they're able to write the return address under their iPostal account. But iPostal, it does have some shipping services, but it's mainly just an address for things to be shipped to. So when we actually do the shipping, we don't use iPostal. We use LetterStream. LetterStream is where you can send post office mail. You can send postcards, letters, certified mail, registered mail, statements, and all of that. I mean, certified mail is only like a couple bucks. It's not that expensive. I think it's like $6. Yeah, and then they give you 14 sheets of paper or less. So they do the certified mail through LetterStream. Then they get the return to be sent to the iPostal address. And the iPostal address gives you a digital receipt of their response or non-response. And so then we can file that into our Google Drive or Microsoft database from there. Then that's pretty much it.
Awesome. That's really great.
Yeah.
Great information. Go ahead.
Yeah. No, but that's it.
Yeah, because I have mobility issues, and that's a big help right there.
Yeah. It's it saves a lot on driving, and it's also more convenient for my international attorneys because they're virtual themselves, and they're needing to correspond and have access to accounts and all that. And this makes it makes it a lot simpler.
Oh, thank you so much. That's wonderful.
No worries. Lovemore, let's go to you.
Hey, Paul Michael. And
hey,
Sam. So my question is about the attorney fee total and the advisor fee total.
Right.
So which one is $350 a month?
That is the average rate of an attorney when you source. It's kind of like, think of it like a minimum wage. You know, that's the minimum wage for an attorney, or the going rate of an attorney. But I have some individuals of you that have come to us because, again, you're naming your salary price. So you can name it whatever you want. I have some of you that are paying $700 a month for your attorneys, but you wanted 20 or more years of experience. You want him to have this many cases won in litigation. Pretty much you wanted the best of the best. So depending on what you're sourcing and you're looking for, it's dependent on the way. Like, does that make sense?
Mm-hmm.
Yeah. So that's the high level for that.
Okay, so the advisor, how much is that?
All advisors have their separate fees, which we send contracts to. I don't discuss pricing on YouTube Live, but I'm happy to answer it after I get off of YouTube Live.
Wonderful, thank you.
Amazing. All right, Kelly Richardson, let's go to you.
2 questions.
Mm-hmm.
Do they do the red registered mail? Do I postal or what have you? And also, I want to know if there's also a venue via, I'm pointing at virtual post mail as the entity in which I'm speaking of, doing banking through that, through that mail agent.
Oh, yeah, they do registered mail on LetterStream. Yes, they do.
Okay.
Yeah.
Thank you.
No worries. Super convenient. Carpintero, let's go to you.
Can you hear me?
Yes, loud and clear.
I went and I got a new microphone.
Nice. Congrats.
Okay, my question is, I know I'm just starting on this. Would an attorney help me get the process going a little quicker or not?
Yeah, absolutely. It's really documentation, organization, and what happens. The huge advantage is that a lot of us are coming from various different backgrounds. Me myself, I came from healthcare. Healthcare has nothing to do with law at all. So when I came into the space and I was super excited about discharging and using negotiable instruments and finding about the truth movement, basically another way on how this government's screwing us. Or the for-profit corporations.
Right.
I started saying, wow, I really want to beef up on my case law studying, contract law, knowing the UCC, common law, constitutional law, and so on. It's just a lot to learn if you're coming from the medical field, kindergarten teacher, a plumber, and whatnot. And so really, when we correct to the status, I mean, using just Patrick Devine even as an example, he was doing these processes and studying for over 9 years, not like 9.5 years.
Right.
That's almost like getting a law degree. That's a lot of studying. So yeah, the advantage of an attorney for me was, hey, if I can get him to be familiar with my foundational documentation that I'm submitting for my status correction, and they're familiar with all my trusts that I have in different entities, and they know kind of the administrative process procedure by which I'm trying to execute and the laws that are associated, they can now bring in their expertise of knowing the UCC, common law, contract trusts, and so on, and apply and commercial law and apply it to my situation because they are intimately involved in my situation. Now, the attorney and the advisors are the ones that are married at the hip, because the advisors are the Americans that give the international attorneys the guidance and direction by which they're supposed to do their studying, research, and execution of certain processes. The advisors are the experts. They're like gurus themselves. A lot of them, I'm like, wow, you're on another network. I've seen you before. And they're like, but Mr. Rowland, what we love about your program is you do not allow anybody to see an advisor unless already they have an attorney. And the reason for that is now if by having a buffer between you and the advisor, now we have an individual that can talk at the same level as the advisor on your behalf. Because if you're coming in as like a nurse, for example, or a nursing background, and you're trying to learn law, it's such a discommunication, and it takes the advisor's time, so much time to get you organized and teach you, that it ends up not being a 1-hour job, but an 8-hour full-time job. So now an advisor can take at max only 3, 4, or 6 people a month. But if we all have buffers of attorneys in between all of you, now one advisor can take care of 40 of you. And it just makes things more efficient.
Yeah, my thing is this, because I'm like I told you before, I'm a contractor.
Yes.
So it's totally, I mean, it's all these reading that you have to do on all this stuff is crazy.
Yeah, I know. It's
trying to comprehend everything is it's just not happening.
Yeah.
It will, but with time. But if I can get somebody to get me started, like with all these EINs and then the non-UCCs, all that other stuff, and then we can go into the company after that and get set up and keep going. Then we started out with the foundation of what I'm doing right now, right away, and then we can go into the foundation of the company, and then we kind of move along, kind of walking or crawling, and then walking, and then we can start running. That's what it was my thought, because I've been doing all this stuff and been reading and reading and reading, and it seems that I'm getting not too far.
Yeah. You know what? I really feel you on that. And you know what? A lot of people in this room feel the same way.
What would be a good step to take? I know that you're not giving me advice. What would be a good step to take next? Should I talk to an advisor and then an attorney, or should I talk to the attorney and then an advisor? And
you could book, most people book a consultation with me, and what we're going to discuss is where you're at, where you want to go, but most importantly, what's your vision? Truly, I tell you, the people who have vision are going to be the ones that get their remedy.
Yeah, I got that, but I need help. It's crazy.
Absolutely. Absolutely.
I feel it's like with the businesses I had, I needed help all the time. So even here now, so if I can get some help.
Yeah.
So what do I do? I know you can't say what your fee and stuff costs right now, but you can say it later.
Yeah.
I appreciate that if you do that.
If you'd like to know what my fee is, you can email Paul Michael at creditoracademy.com and book a consultation with me. And it's very reasonable.
I will do that. I will do that. Then we can, because I just want to get this ball rolling.
Yeah. I believe it, man. And I'm excited to get it rolling with you.
Yeah, I got a few things done, but to get the next one down, I need to comprehend exactly what I'm doing, because I don't want to like trip.
Yeah.
And once you trip, you got to get up and dust, but it's a lot of stuff. It's not easy as it looks.
Yeah, absolutely. And you're right. It's a lot of studying and all of that. That's why, when I looked at gurus, when I first came into this market, as I said, well, I mean, I'm super impressed by a lot of people in this movement. I'm very thankful for a lot of the gurus, because to a large extent, they're the ones that are waking people up by pointing out the fraud. It's just so difficult, because when you look at a teacher or a guru, you want to emulate them by kind of going the path that they went on to, like a teacher, like, hey, how did you get to the knowledge that you know now? And doing 10.
That's what about you.
Yeah, right. And it's a lot to learn. And I've read a lot to get to where I am now, and I've gone through a lot of organizations and all of that. And I know a lot of you are brand new. And And really, after all the books I've read, after all the processes I've done, the hundreds of hours of videos that I've watched on other channels, I just said it's much easier to be organized and have staff than trying to be something that I'll never become, which is an expert at law. Because you need, in order to become an expert at law, you need structure.
Right, right.
And if there's no structure in the movement and it's not being offered, then you got to think outside the box on how you're
Right.
going to do that.
It's like that copyright I asked you about yesterday.
Yeah.
I emailed Dawn, but I haven't got nothing back. So the attorney might have said, "Yeah, I'll fill it out for you, send it out." It's like perfect.
Yeah.
You see what I mean?
Absolutely.
Certainly would have just got it filled out. He has my information. Let's do it, and it's done.
Mm-hmm.
That's how I had my attorneys here with the companies. So
yeah.
So yeah, I'm gonna email you. You say Mike.
Paul Michael at creditoracademy.com. Absolutely. All right. Val, thank you for that. Carpenter.
Yeah.
Yeah.
Carpenter, remember? Carpintero.
Yeah. Carpenter. Exactly. Look forward to having a meeting with you, my friend.
Sounds good.
No worries. Elle, let's go to you.
Yes, Paul Michael. I just have a couple of quick questions. I know we're sending the non-UCC, but I heard tonight that we're supposed to send the UCC 3 also with that.
Well, UCC 3 is in order for you to show what your secured party has control over as collateral. So whether it be a vehicle, a summary judgment, a case number, a mortgage title, DD 214, other securities or instruments, bonds, it could be anything because you're listing it as collateral that the secured party has control over.
I kind of typed up everything in the collateral because Louisiana doesn't give you much space to put much in the collateral space. Do a page, and I have like basically a page and maybe a half for listed, but I have it formatted like theirs. And one other question I needed to ask you, and that's it. You said the administrative process documents we go to sales at Creditor Academy?
Oh, you'll email creditoracademy@gmail.com, where you can also get the link to these live courses that we have if you would like to become a student to our organization.
And are you taking other attorneys? Are you seeking?
Yes, I there's no shortage of attorneys for
I think I know an attorney. I'm gonna talk to him and see. He's from New Orleans. I'm gonna see if he wants to join you.
Hey, that would be solid. Great to find the American-based ones, Very knowledgeable. Yeah, definitely. Well, thank you, Elle. I appreciate that. Let me go to the last question. Steve Clary, let's go to you. No? Okay. Tech Control, let's go to you.
Hey, Paul, just a quick one about the affidavit in the process. So once that's established, it becomes truth in law, right? So when you get it notarized, etc., are you in a position to then call upon other people's affidavits that have done this process already and reference that as like truth in law status? Do you know what I mean? It's like
I see. So you would have an affidavit of truth statement.
So if it's got a public case number, for example, you could refer to it.
Oh, yeah, you can refer to anything in your affidavit of truth and list out what it is, like just the facts of the matter.
Yeah. So the more people that do this kind of build up a bit of a sort of a database of these affirmations.
Yes, to a certain extent, but everybody's contracts are a lot different. So there's nuances that can change depending on the organization that you're going to.
Okay. Yeah, but it builds some weight towards kind of affirming that, I think.
Right. Exactly. Exactly.
All right. Thanks.
No problem. I want to thank everybody that joined us on YouTube today as we went over our final day of going over the administrative process step by step. This is the foundation by which you should be doing your processes when you go ahead and have your status correction already done, or your when you separate your assets from your business trusts, and now you're getting into doing processes. This is going to keep you organized, and it's going to get you, most importantly, to stay in honor. Next week, what we will be covering is we will be touching upon another process that I'm just kind of getting my teeth around on how to explain. You'll have to wait until next week on Tuesday when we go over on that. But we do have our live course for the structure of your private bank, which is offering, where we're offering the instructions on the 3 EINs, why Patrick Devine needed them and how he used them. If you'd like to sign up for that course, you can email classes@creditoracademy.com. Before I leave you all on YouTube today, we will finish today with a commercial. Amazing. For our business trust course.
Good day, everyone. My name is Mike, and today I have the pleasure of introducing you to the Business Trust course offered by Creditor Academy. This course is designed to provide an in-depth understanding of business trusts, a powerful tool for managing and protecting business assets. In the modern business landscape, trust structures are increasingly becoming a vital component for entrepreneurs and business owners. They offer a multitude of benefits, including asset protection, tax efficiency, and succession planning. However, navigating the complexities of setting up and managing a business trust can be daunting without the right knowledge and guidance. Creditor Academy's Business Trust course is meticulously crafted to demystify these complexities. Throughout this course, we will explore the fundamental principles of business trusts and their various types, the legal and regulatory framework governing trusts, strategic uses of business trusts in different business scenarios, practical steps for establishing and administering a trust, real-world case studies that highlight the advantages and potential pitfalls of business trusts. Our goal is to equip you with the expertise to confidently leverage business trusts in your professional practice, ensuring that you can offer robust solutions to your clients or enhance your own business operations. By the end of this course, you will not only understand the theoretical aspects of business trusts, but also gain practical insights that can be applied immediately. Whether you are a financial advisor, a business owner, or simply someone interested in expanding your knowledge, this course is tailored to meet your needs. Thank you for joining us today. Let's embark on this journey to mastering business trusts together.
Amazing. Thank you, Mike. Awesome. Again, business trust, if you have never operated in the private before, this is the place you should start. Instead of messing with your private banking operations, you can operate in the private today. Separate your assets, get privacy, protection, know how to do hire employees, how to open up bank accounts, how to do international banking from 180 different countries. Know what the difference is in different trustees and personal entities that can own a trust, and how to select your beneficiaries, and most importantly, how to fill out that SS4 form for your trust, and so much more. This business trust course is very comprehensive. We have 2 offerings of the business trust course that are available right now. We have the quick start guide. Hey, I just want to get my business trust started and off the ground today. What does it take to get me to do that? And then we have another course, which is the whole enchilada. It is not only inclusive of the quick start guide, but also covers all of the things I just mentioned earlier, plus more. If you'd like access to our business trust course, please email classes@creditoracademy.com. I look forward to seeing you all on YouTube next week, Tuesday, and take care of yourselves and your family in the meantime.
Thanks, Paul.
and not even a handoff.
Mine's up.
Hand off, not hand up. Usually he hands off the program to
Just